When conflict escalates in an organization, the instinct is often to act. And there's immediate pressure, often relationships unstrained, and at times even leadership credibility may be tested. Someone may even say something like, something needs to be done. The risk is not how you act. It is actually in how you classify the problem before you act. And how you classify the problem is going to determine the process that you follow. So the classification actually is going to determine your procedural fairness. We know that Section 188 of the LRA recognizes three legitimate grounds for fair dismissal. These are misconduct, incapacity, and operational requirements. And each of these grounds trigger a distinct procedure before a fair dismissal can be effected. So if you get the classification wrong, you're going to follow the wrong process. And in an unfair dismissal dispute, the employer bears the onus to prove fairness once dismissal is established. So both procedure and substance needs to be established and needs to be fair. If you misclassify incompatibility issue as misconduct, you may end up disciplining personality instead of proving fault and exploring remedial options. Where you misclassify misconduct as incompatibility, you may end up bypassing progressive discipline, and misclassifying can render the dismissal process unfair, and it is completely avoidable. This webinar is going to look at how classification sits at the heart of fairness and why getting the diagnosis right determines the fairness in terms of the process and the substance. My name's Kerith Kieser. I'm the CEO of Kieser, South Africa's leading accredited private dispute resolution agency. And today we're going to unpack how to avoid the most common pitfalls in misclassifying incompatibility and misconduct. Is the problem fault or fit? And this is essentially the strategic question you need to be asking. Is it a failure of conduct, or is this a failure of compatibility? If it is fault, we're required to apply misconduct principles. However, if it is fit, we apply the incapacity principles. The mistakes that I see in practice are sometimes just a failure to identify whether it's fault or fit. So is there a fault, or is it about capacity? And the Code of Good Practice has placed incompatibility squarely under incapacity. And yeah, we've got in the code, it's got section 21.7 says that an employee's incompatibility as manifested by an inability to work in harmony with the employer's business culture or with fellow employees can constitute a form of incapacity which may justify dismissal. So essentially, this is about fit. However, on the other side, you have misconduct on the other hand. This is about fault, where there's been a breach of a standard, where there is that element of intention or negligence, recklessness, or even defiance. Here it is about fault, and we're going to explore each of these a little bit further. So yeah, we've distinguished between the two, and we know that misconduct is fault-based. Yeah, there is a standard, what rules being breached. And if there is fault, there's often that intentional, there may be intent behind it, it may be reckless or even negligent. But with incompatibility, we're looking at capacity-based. It is not about blaming the individual. It's about there's that relationship breakdown, and sometimes it has an impact on performance, but it isn't, the employee is not necessarily at fault. It is not something that they can change. Misconduct requires corrective behavior and applies discipline. So here we're looking at, is there a rule? Did the employee know about the rule? Was that rule broken? Incompatibility, on the other hand, actually tries to restore relationships and requires support, remedial interventions such as counseling and mediation. Misconduct, you're trying to correct the behavior through disciplinary processes and their progressive discipline. Misconduct requires proof that there's been a breach of standard, that there is a standard, that the employee knew the standard, and that standard has been broken. There is fault. Incompatibility requires proof that the employee is actually the cause of that disharmony in the workplace, and that there's been an irretrievable breakdown in the relationship. And it's a key differential. And the process, as well as the evidentiary burden on the employer and the employee in these matters, differ substantially. Your investigation as well will uncover which process to follow, and it is important to identify early on what the cause is behind the behavior, what is causing this disharmony, what is causing this behavior, in order to identify which route to go and which process to follow, whether it is misconduct or incompatibility. Incompatibility isn't new. And an employer, our law is very well established that an employer is entitled to insist on reasonable, harmonious interpersonal relationships within its business. And it's also demonstrated in this case, which is Wright versus St. Mary's. It's one of our very earlier incompatibility dismissal cases from 1992, where it was established that in this case, it's about an employee who was a medical superintendent and who was dismissed for undermining authority. The allegations included incitement and as well as losing his temper. And in this case, the court held that dismissal for incompatibility is only fair where the conduct has caused an irretrievable breakdown in the employment relationship. And importantly, the employer must first attempt to address and remedy the incompatibility. And if the employee is considered the source of the problem, they must give a fair opportunity to that employee to correct that behavior. They must be given that opportunity before dismissal may even be considered. The Labour Court found in this case that these conditions were not met and the employee was reinstated. But the case provides us with guidance on the procedure to follow for incompatibility dismissals. And right early on, as far back as 1992, and this has been reflected in future cases. But the key takeaways here is that there must be an irretrievable breakdown in the relationship. And this needs to be proven with facts and evidence, not just because I think there's incompatibility or the employee doesn't fit. You need to have hard evidence to support those allegations. The second thing that it points out is that the employee is the source of this disharmony. And thirdly, that they must be given an opportunity to correct behavior. And here it gives us guidance on what expected is that the employee needs to be informed of the allegations and be given that and the reasons for why you view that there's disharmony in the relationship, and provide a fair opportunity and give that employee an opportunity to remove that disharmony and correct behavior. A more recent judgment, but also one that was quite early on and has been relied on quite heavily in cases, has been Jabara versus Telcom. And it emphasizes that the employer sets the standards for harmonious interpersonal relationships. So the employer needs to set what those standards and what it looks like. And Jabari actually gives us guidance to conducting in what conduct relates to disharmony in the workplace. When it's where it provides and emphasizes that the employer has the prerogative to set those standards pertaining to what harmonious interpersonal relationships look like in the workplace. And in this case of Jabara, the employee was dismissed on the basis of attitude, behavior, and they cited general personality being incompatible with the employer's corporate culture. And the court held here that the employer has the onus of proving not only that the incompatibility exists, but also that the employee is substantially responsible for the disharmony, that they are causing the disharmony in the workplace. And this case goes further on to say that, in addition, an employer must also prove that they've followed the correct procedure setting out with regards to providing the employee opportunity to present themselves, provide their version, and giving them a reasonable opportunity to correct that behavior. But Also, that there is an onus now on the employer to provide support. And in this case, they cite counseling to that employee to assist them to correct that behavior. You can't just let the employee know that there's an issue and leave them on their own. You actually need to give them support to correct that behavior and fit in within the organization. And so in Jabara, the courts held that the employer failed to discharge this onus on proving that there was a procedure followed. The employer in this case had not established that the employee was at fault. It had not established that there was incompatibility. But essentially, while the employee was given a chance to confront the allegations and respond to them, they had not received counseling and they were not given an opportunity to remedy this incompatibility, and the employee was reinstated. The Jabara added, the procedural requirements that counseling is afforded as a remedy to remedy incompatibility and should have been followed in this case. So while the employer can reasonably expect harmony within the workplace, they must establish the cause of the issue and the problem, what's causing this disharmony, and try to implement remedial measures. And in the matter. Another case I want to look at is Azida, and this case is about Van Dijk, who was a long-serving senior manager at Avis, and she was responsible for overseeing key accounts in the Gauteng region, while her colleague Freebie managed new business acquisitions. And over time, they developed a deeply conflictual relationship between these two employees, marked by mistrust. There was poor communication and ongoing tension, and this tension ended up expanding or filtering down to the team members and affecting their teams. But often internal disagreements and complaints, the company brings in an external facilitator in an attempt to try and resolve this disharmony, but the relationship doesn't improve. Management at this point now begin reconsidering the structure of restructuring the sales division, and they proposed consolidating the two general manager roles, which would mean that one of these individuals would become redundant. But both were invited to apply for this new role or consider severance package. Van Dijk, in this matter, raises concerns about fairness in the process and believed that there was a predetermined outcome, and did not. Now, at this point, she does not go and apply for the position within the deadline and was ultimately dismissed on operational requirement grounds following this restructuring process. It went to the Labour Court and then was taken to the Labour Appeal Court. And the Labour Appeal Court agreed with the Labour Court that the dismissal was substantively fair and that the restructure could be a rational business decision to address incompatibility. However, the dismissal was procedurally unfair. The company had failed to make any consultation. The decision to merge the post was made without consulting these two individuals that were concerned. There was no meaningful consultation or discussion with these individuals. There was also no discussion around what the selection criteria would be. And the court says that simply requiring employees to apply for a new position, it cannot be a selection method, particularly in this case. The employer effectively treated Van Dijk as deselecting herself, which they said was problematic. And the outcome had appeared to be predetermined. So the case was essentially saying is you need to follow a proper procedure, and not just in matters of and identifying up front and deal with matters as incompatibility. You can't cover them up as a matter of operational requirement or misconduct or any other matter. It must be dealt with as incompatibility, and in this case was found to be procedurally unfair. The case goes further. There's other interesting parts to this case. For those who are familiar with it, is that it highlights the determination around compensation, and that it is actually a redress for the loss of a right, not a compensation for loss of earnings, but a redress for the loss of the right. And the employee in this case received 7 months compensation. So it does go further. But when we're looking at incompatibility, is that the key things and the takeaways around this was that it was incompatibility that was issued. It wasn't operational. And incompatibility is generally treated as a form of incapacity and cannot follow the same procedures as operational requirements. The employer should have identified what the cause of disharmony is. They should have proposed remedial steps and taken meaningful steps to try and resolve. Having once-off matter of mediation between the two to try, or an external facilitator is a good way to start, but you cannot stop once you've thrown something at it. Give the employee an opportunity to improve. Let them know what the issues are. You need to ensure that they understand that this is not congruent with company culture, that there is a misfit, that the behavior is causing that disharmony, and give them opportunity to improve. And before you even consider dismissal, you must first establish that there is irretrievable breakdown. Distinguishing the issue is relevant not only for misconduct but also for operational matters, and it is certainly relevant in terms of determining right up front what the cause is of this disharmony. So I've said incompatibility is not new. It's been well established in case law leading up to the issuing of the Code of Good Practice. The Code of Good Practice in 2025 very clearly places incompatibility under incapacity. And it describes incompatibility that may arise from the employer's inability to work in harmony with its colleagues, fit into the work environment, and it may affect performance. And it has removed any debate or uncertainty around what process needs to be followed when an issue has been recognized as incompatibility. And the principles from our case law leading up to the issuing of the or the release of the Code of Good Practice last year is that those principles still stand true, that you must attempt remediation when there is incompatibility. You must identify if the relationship has broken down irretrievably. There must be independent corroboration in terms of the evidence to support that breakdown. And the primary cause needs to be that employee's behavior causing that disharmony. We know that it is a species of incapacity, but the employee must be given an opportunity to resolve those issues. The principle underlying all of this is around fairness particularly to the employee. So if we take all that case law and we look at it, there's essentially 5 questions to test whether where something should fall. And before you draft charges, initiate proceedings, if you're preparing to represent an employee at an incapacity hearing or at a disciplinary or a matter of operational requirements, these are some of the questions that you can ask. And the first being, what are the facts? What actually happened? What are the facts, not the impressions? What evidence is available that's going to prove those facts? And can you describe the issue as observable behavior? What are the events, the dates, the words and actions? Who was affected? If you can describe those, it will give you a good starting point on starting to understand what the cause is. Then the second question is determining, is their fault? Is it a matter of won't? Which would be fault, I just won't do it, or is it that the individual can't? Is it related to capacity or fits? If it is won't, there is deliberate action or negligent breach. There needs to be a clear standard in place to determine misconduct. If it is a matter of can't, the persistent inability to work harmoniously, meet role expectations, even when feedback has been given, may indicate that it is a matter of incapacity relating to incompatibility. So what is the clearest standard? So what is the standard that's been breached? And yeah, if it's a matter of misconduct, what rule has been broken? Was the employee knew about the rule, or should they have reasonably known about the rule? Has the rule been understood? Has it been consistently applied in the organization? It is a matter then relating to conduct and misconduct process. Following progressive discipline would be appropriate here. However, if it is a matter of incompatibility, you would be looking at matters of performance, behavioral expectations, what behavior would apply, and were they made explicitly clear to the employee what is expected of them. Also, what standard was breached, and what remediation has been attempted. So what corrective steps have been taken to rectify it. So if it is a matter of misconduct, you follow progressive discipline. You'll need to determine what level of discipline to apply. With progressive discipline, you would start looking at whether it is a warning, a final written warning, or whether it would go into a disciplinary hearing to determine whether dismissal would be appropriate in the circumstances, or if a lesser sanction should apply. With a matter of incompatibility, you would be looking here at remediation. What support has been given to that employee? And you'd be looking at things such as coaching, mediation, making sure that you clarify roles and performance standards and behavioral standards with that individual. What accommodations can be given to them to try and support them? And possibly even looking at redeployment. What would be reasonable in the circumstances, and have you given the employee a real chance to improve? And both Wright and Jabari cases are very relevant here in ensuring that employee has been given an opportunity to correct that behavior. So those are the 5 question steps, or the 4 questions that would sit here. And then also the 5th question, which isn't reflecting on the screen here, is looking at what evidence exists that is fair, reliable, and corroborated. So what can each side point to? The documents, the witnesses, the performance metrics, what warnings, coaching notes, what are you replying? You cannot rely on opinions. It needs to be provable, independent facts. So what facts support your conclusion on whether this is a matter of misconduct or incompatibility? The causation threshold, it's asking the question is around what the cause is. First of all, is to start looking at, is there disharmony in the workplace? And if there is disharmony, what is causing, or who is causing that disharmony? Is it a matter of behavior causing? Is it a matter of behavior, or is it a matter of misconduct? And sometimes it could manifest as misconduct. Sometimes it may be a matter of insolence, insubordination, or some of the behaviors that might come through as misconduct. You need to identify whether it is a matter of misconduct, or is the behavior, or is it a general matter of behavior causing general disharmony, and is it ongoing, not just a once-off instance? So was it the employee that caused that conduct? So when you're having a look at who caused it, they must have substantively caused that disharmony, and it must be related to their behavior. The other factors that you might contribute, that might be contributing, it could be other employees. Is there organizational dysfunction? Could there possibly be a leadership style that is causing that conflict, and is that breakdown irretrievable? So identifying what that cause is. And then finally, can it be fixed? Can you fix this? And there is an obligation in matters of incompatibility for the employer to take meaningful steps to try and rectify things. You must prove that the employee substantively caused the breakdown, and not merely that the relationship's been strained. Then, at this point, you may want to pull in and conduct a thorough investigation to collect all the evidence and the facts to determine whether this is what remedial steps should be taken, and if it is a matter where it has irretrievably broken down in the relationship. Once you've determined whether it is a matter of misconduct or incapacity relating to incompatibility, it will determine what steps you follow. And the process steps are really important in that you need to both have for a dismissal to be fair in terms of the Code of Good Practice and the Labour Relations Act. There needs to be procedural fairness as well as substantive fairness. And for it to be fair, you need to follow the right process. If it is a matter of misconduct, you would first investigate. If it is appropriate, follow progressive disciplinary steps. Then if it is a matter that is very serious that might qualify or it might lead to dismissal, or if it has been a repeated incident that has happened, you would then implement an inquiry, a disciplinary inquiry. And in the disciplinary inquiry, if somebody had been found guilty of misconduct, you would consider sanction and whether dismissal would be appropriate given the circumstances in the case. With matters of incompatibility, you would identify the issue. And you would also investigate if it is appropriate to do so, but you would consult with that employee and those who have been affected by the disharmony that's been caused. You would consider remediation and support that employee in the steps to try and correct that behavior. You would also consider alternatives, what could be available in terms of remediation there's an obligation on the employer to find steps to show that they've tried to correct this situation and give the employee an opportunity to change their behavior. And if necessary, it may end up in an inquiry. And finally, if that relationship has been broken down and the evidence supports that breakdown in the relationship, then it can lead to dismissal. So some of the red flags just to look out for is and when to be cautious in these matters and managing these matters is if there isn't a rule cited. An employee cannot be found guilty of misconduct if there isn't a rule and they did not know that rule. It cannot be misconduct. And the same as with incompatibility. If you have not raised with the employee what is expected of them and expressly said to them, this behavior is not acceptable in the workplace, this is what we expect of you, we cannot find incompatibility. They need to be aware of what that issue is, regardless of where it is classified. But in incompatibility, there needs to be intervention. If there's been no intervention, then it should be raised as a red flag, because with incompatibility, we know now that you need to be giving the employer an opportunity to correct that behavior, and there needs to be some sort of support from the employer. Be wary of allegations or charges that include things relating to bad attitude. So others that I've seen have been negative energy or creating a toxic environment or just doesn't fit the culture of the organization. Be wary of these type of bad attitude labels, because there are labels. What is actually required when you're drafting allegations and in determining incompatibility is observable conduct. You need to be able to say what that observable conduct is, what corroboration in terms of what evidence and facts support what it is that is being raised, and what supports causation. And the employee needs to be the substantial causing that disharmony. So be wary of what of these labels being used in charges of allegations raised against an employee. And where there's no evidence of breakdown, if someone be wary, where someone is cited as a problem employee, and is that just labeling once again that individual as a problem employee could be problematic, in that where an employer could just be looking for a charge and not really having that substantial evidence to support those charges. You cannot just say that somebody is a problem employee and therefore it's incompatibility. That is not going to fly in the courts. You need to be able to have substantial reasons to be able to show that the employee is causing that disharmony, what disharmony looks like in your workplace, and that they've been given an opportunity a real opportunity to correct that behavior. So In matters, even if the classification, you get the classification correct, it needs to be on you need to have substantially fair reasons to dismiss an employee, and the sanction also needs to be fair. So the Code of Good Practice speaks to the fairness relating to sanction. With misconduct, you need to follow progressive discipline. And there are matters where conduct is so serious, it can lead to dismissal in the first instance, but it needs to follow the right procedure. It needs to be substantively, and the sanction needs to be fair given the circumstances. With incompatibility, the sanction, the outcome is the breakdown irretrievable. What was the cause of that disharmony, and does the evidence support it? And finally, fairness, once again, that golden thread of fairness through all our labour laws. What would be a fair outcome in this matter? And if it is a matter where the employer hasn't provided that support, as with Jabara and some of the other cases we've looked at, is that if they have not provided adequate support, the employer, it may be found that dismissal is unfair. So the classification determines fairness. It determines your process, which will determine fairness. The causation, that the employee is the source of the disharmony, determines your substantive fairness. And there needs to be evidence to support both of these. The Code of Good Practice states that for a dismissal to be fair, there needs to be both that fairness in both the reason, in the substance, as well as a fair procedure. So both of those need to be present. And for employers, you want to document your reasoning. Make sure that you prove causation, investigate objectively, gather the evidence to support it, demonstrate that you have taken remedial steps, make a genuine effort to correct that incompatibility. And then for employee representatives, go and interrogate classifications, but do it early on. Test the evidence, challenge where there's been issues around procedural shortcuts, ask questions, and ask for support when it is appropriate to do so. The Code of Good Practice settles the debate, if it even was a debate in the first place, but it has cemented that incompatibility is now expressly recognized as incapacity, and employees must follow the incapacity process. It requires fairness and an opportunity for the employee to respond. Ultimately, you need to ask, was the correct procedure followed? Was it fairly applied? And what would be a fair outcome? So investigate objectively and gather the facts and evidence, and make sure that you're making genuine effort to correct matters relating to incompatibility. So contact us. These are tricky processes, and sometimes they are complex. So Kieser does provide, we've got excellent investigators, we get this right. We've got presiding officers with experience in determining the difference between these matters that can come in professionally and ensure that you get this right the first time round as an employer. So contact us if you do want more information around our presiding officers and who would be suitable. We've got a panel of 200 panelists, and we will be able to help you identify the suitable process, but also the right panelist, given the complexities of your matter and case. And once again, I just want to mention, contact Worklaw. We aren't able to give you advice on your case from a substantive perspective. And if you do have a tricky situation, Worklaw has got a lovely service where you can, which you can subscribe to and have access to very clever lawyers and professors who can answer your questions relating to substantive matters. I am going to very quickly mention that we do have the next webinar that is taking place on the 1st of March. Tanya is going to be presenting this one. So you're welcome to sign up for it. It is up on our website. And we do have upcoming courses. We've got an arbitration course, how to prepare and present at arbitration, taking place in Sandton on the 31st of March. So if you want guidance on what to prepare when you're presenting at arbitration around the CCMA, bargaining council, at a private agency, then this course is probably for you. We also have a course on chairing disciplinary inquiries. And this is one of our flagship courses. This one's happening on the 15th and 16th of April. It's also in Sandton. And this is to build the skills to chair disciplinary inquiries and includes our wonderful board game, which is a hell of a lot of fun, but takes you through the process as a chairperson through the different steps on making where you make practical decisions throughout the board game, where you need to make calls as a chairperson, and it determines whether you move forward or not. Our Snakes for Chairs board game. So thank you very much. I am going to have a look quickly whether there are any questions. Let's see. There's been a couple of comments. Sorry, Haley, I'm only seeing now that there's an echo. I hope that's been resolved. Relebohile has said an informative and eye-opening session. The topic's often avoided by employers for a very long time, bringing animosity between employees. Yes, it does. It does create, and if the matter isn't dealt with, what we have seen is that the behaviour actually escalates, and sometimes comes is brought to through misconduct matters where it has been incorrectly identified because the behaviour has developed so far. That it starts showing up as insolence and insubordination, and creating that animosity between employees. And if it's not dealt with, it can roll out into teams, as we've seen with one of the other cases we dealt with today. Usual remedy is to transfer employee one to another. So thank you for that comment. I'm just having a look here, and for some reason, I am not seeing I just want to make sure that I can see our questions in the Q&A. There we go. Can you have charges for both incompatibility or misconduct, or is it better to have one or the other? I think it's a good question, and what you want to do is identify what is the cause of the behavior, because it will be different processes for the different distinguishing between whether it is incompatibility or misconduct, because you're going to identify different processes. If it's a matter of misconduct, you're going to be applying progressive discipline. If it is a matter of incompatibility, then you're going to be providing remedial support, and it is a different process. So I would be going back and identifying what the cause is and what is the primary reason for that disharmony. Is it a matter of misconduct or incompatibility? And certainly sometimes misconduct may be easier to prove, but if you're getting it wrong and you're going with misconduct matter, you're not going to be able to, you may fall short in finding that somebody is not, that procedurally you haven't followed the right process. Another anonymous question, is it not easier just to use the misconduct route based off past cases, not easier to prove? Yes, it may well be easier to prove, but once again is that if you have a chairperson or a commissioner that picks up that this is actually a matter of incompatibility, you may find that you have not followed the correct procedure, and somebody may be reinstated, as with Jabaru, where it was found that the employee wasn't given opportunity to remedy their behavior. Is it not easier to dismiss an employee using misconduct? So I see that that's a similar question to the one previously, so it's been answered. And if you, what do you do if you have an employee who is a problem employee but improves well a bit when you speak to her about the behavior, but then starts and relapses in behavior after a while? Make sure that you've got record of what you have done and what processes have been followed up until that point, because once you have provided an opportunity and an employee relapses, you do need to give them more opportunity. But the level of support that you provide to that employee and the level of opportunity may not be as elaborate as what it might have been in the first instance. So the amount of support and the onus on the company in providing support when the employee relapses is going to reduce, but you still need to follow that process. Meet with the employee, make sure you've identified the cause of the behavior and that it is incompatibility. So thank you, Elias. And I see there's a question relating to whether the recording will be available. Yes, it is. It takes a day or two and will be up on our website. We'll also send out an email. Our team will send out an email to share that recording. Another question, Bulawa, thank you. It's still incompatibility if the department manager is incompatible with almost everyone in their department. It could be, Bulawa. I think, yeah, you would need to follow a investigation process might be relevant in this case to identify, because sometimes incompatibility is not just, it's a misfit within the organization, and sometimes not just a relationship issue with one person, but it can be multiple individuals that the person is bumping heads with. And certainly it could be seen as a matter where sometimes it arises by numerous grievances being raised against one manager. Sometimes it arises through just complaints being or rumblings within the workplace, individuals not wanting to work with that individual. So certainly, yes, it could be incompatibility. Go back, gather the evidence, investigate, understand, meet with the individuals, and offer remedial options and support to that manager, to that department manager. There was a question, yes, another one. What will happen in a situation when an employee was given only an opportunity to do representations without a disciplinary inquiry and dismissed at the end? It depends on the circumstances. So the Code of Good Practice, if you're talking about a disciplinary process, I assume that would be related to misconduct, is that the process does not always need to be a formal inquiry, is that the Code of Good Practice is actually leaning towards having a more informal process for matters of misconduct, particularly for smaller employers. So if you're saying that the situation where the employee was only given an opportunity to do representation without disciplinary inquiry and they were found guilty of and dismissed, is that the employer will need to show that they followed a fair process and that they had fair substantive reason to dismiss that employee. And in terms of the code, it is a right to respond to the allegations. Sanction needs to be considered. Matters such as were there prior warnings, matters relating to the seriousness of the misconduct, and things such as length of service, etc., would be considered in sanction. So all of those things would need to be present. Nebochong's asking for the presentation. And another question is, if you're more senior, would a different standard apply? And that is an interesting one as well, is that you should, I think the more senior somebody is, the more expectation an employer can have with that individual on that they would know what behavior is appropriate in the workplace. So the more senior you are, there's more expectation that there's less onus on the employer to explicitly explain to you what behavior is appropriate for that role. So I do think that you would still need to, for somebody senior, is meet with that individual, make sure that they identify whether it is their conduct and an incompatibility matter, if it is them causing their behavior, causing the harmony, making sure that they're aware of it and given an opportunity to respond and to correct that behavior. But I do think that you can expect more the more senior somebody is within the organization. And then yeah, so I don't is incompatibility. I think I've answered all of those. Carl's asked, how does one deal with an employee who constantly lodges grievances? I think, Carl, I've had this question recently. I was facilitating a group last week and somebody asked me something similar around an employee who just constantly raises grievances. I think you need to understand what the cause is. Is the employee not fitting within the organization? Is it about them, or is there something else or an underlying cause? Because sometimes it could be a number of grievances within a department from a single individual or about a single individual can sometimes highlight other underlying issues within the organization. So yeah, I think you might want to investigate and maybe meet with that employee and understand what is happening with what the source of these grievances are. But there is a possibility of incompatibility here, but don't try and cover up something if there is through incompatibility, if there really is an organizational dysfunction somewhere and this person's got a valid reason for those grievances. Thank you very much. I do hope to see some of you at our upcoming training courses soon, but you're welcome to contact us if you do have questions around process or any matters relating to this. You're welcome to contact me. My email is kerith@kieser.com. Otherwise, you're welcome to go to our website. These are over there. Our contact details are there. And if you do, you're welcome to we're happy to chat. We're not able to provide you with substantive reasoning, but it's been wonderful to be here today. Thank you for the interesting questions, and I look forward to our next webinar and chatting to you then.